Under the torrent system, once an interest on a parcel of land is registered, the ownership of the proprietor cannot be challenged on the grounds that the land had defects existing prior to registration. This is known as indefeasibility. The principle of indefeasibility hails back to South Australia in 1841, when Sir Robert Richard Torrens took up post as a collector of customs in Adelaide. Upon realizing the dependent nature of the old system, he insisted that land title should be independent, that is, that land title should be indefeasible. Torrens consequently championed the Real Property Act in 1858, and today, countries such as New Zealand, Canada, Singapore, Malaysia, Hong Kong, and Israel have all adopted the Torrens system. This simplification of land transfers naturally led to an opposition from legal professions, as it would have reduced the earnings of some legal practitioners back then. In particular, a judge was dismissed from his office due to his pedantic approach to imperial law, suggesting that some of South Australian statutes, such as the Real Property Act, were invalid. His name was Benjamin Boothby. The fundamental idea of the Torrens title was to create a register which displayed all proprietary rights on a piece of land. According to Section 31B of the New South Wales Real Property Act 1900, the register is comprised of portfolios, dealings, prescribed instruments, and records the regulation may require. It also holds information on the land, estates, and interests in land, along with descriptions of the owners of those interests, and any other information that may affect the land. This register is run and guaranteed by the government. This guarantee by the government prevents the need to investigate the chain of title. Moreover, the state guarantees the registered owner's title, meaning that he or she has an indefeasible title. The principle of indefeasibility came into effect by the following provisions in the Real Property Act 1900. In Section 42, known as the Key Indefeasibility Provision, the proprietor listed on the register holds the land free of any interests which are not listed on the register. And Section 43, known as the Notice Provision, where once a person completes a transfer from the rural owner or the proprietor, he is free from any trust or unregistered interests, even if he had notice of that interest. Now, we look at two concepts known as immediate and deferred indefeasibility. These two doctrines are concerned with a situation where a person forges a signature of the real proprietor on a transfer and sells a property to an innocent purchaser. Both the real proprietor and the purchaser are innocent, and both want to claim the property. The concept of both immediate and deferred indefeasibility is opposing in nature. Immediate indefeasibility occurs when the purchaser obtains an indefeasible title once that person registers and transferred a property, regardless of the fact that the document was invalid. He then becomes immediately indefeasible. The deferred indefeasibility is when the purchaser's title is defeasible and can be set aside if the real proprietor makes a claim. However, if the purchaser transfers his title to a new purchaser before such claim is made, then the new purchaser's title becomes indefeasible. Ultimately, the dilemma in both doctrines is which rights should be protected more. Should it be the purchasers or the property owners? The doctrine of immediate indefeasibility, which protects the purchaser during purchases, will also increase his vulnerability to losses, theft, or forgery in his title during his ownership. This brings us to the case of Provident Capital Limited and Printy, which made a point that the principle of indefeasibility is subject to fraud. The case raises the exception to indefeasibility of title on whether or not a mortgage was obtained by a fraudster without the knowledge of the owner was effective. In this case, Printy purchased a property before living in America. During his absence, a rogue was able to fraudulously obtain a replacement certificate of title. This person who fraudulently obtained the certificate of title then mortgaged the property into two loans. First mortgage was to Provident Capital Limited, and the second to Bruce Jones and Robert McDonough. The person who obtained the mortgage defaulted the mortgage repayments, and the finance company who supplied the mortgage exercised its power of sale under the mortgage contract. The owner then discovered this and brought an action towards two loaners to void the mortgage in the Supreme Court. The finance company argued that it has statutory rights to repayment of the mortgage. The central issue for court was to decide whether or not the registration of the mortgage provided indefeasibility, notwithstanding the existence of fraud. The court found that the Provident mortgage referred to the deed of loan where the mortgagor must pay the money secured in any related documents, which is ultimately because of forgery was held to be a nullity. The Jones and McDonough mortgage was complete as it stated that the mortgagor had received X amount of money and was obliged to repay the same amount with interest without any correlation of related, and was found valid. The first mortgage involved was an all monies mortgage, where the mortgage itself does not refer to the sum secured but instead refers to an unregistered collateral agreement. In these circumstances, even though the mortgage is protected by indefeasibility, it secures nothing because a collateral agreement is found to be void. The court so held, and upon the same analysis of the second mortgage, which did not use an all monies clause, was found to be indefeasible, and the money could not be recovered from the lender. Excuse me. Provident Capital lost a principal amount of $550,000 because their documents were not optimized to protect them from fraud. Had they taken the simple precaution of adding an Annexure A to the mortgage defining the loan's parameters, then the story would have been quite different. Would Mr. Printy, the innocent victim of fraud, have lost his house in that case? The answer is no. Had Provident won and Mr. Printy lost, it would have been entitled to recover compensation from the Torrens Assurance Fund. The Torrens Assurance Fund is designed to compensate anyone, lender or owner, who is cheated out of registered interest by fraud. It is a scheme whereby the state insures title. Torrens title is often said to have the benefit of indefeasibility, which means that when a person becomes a registered proprietor of land, that title is not subject to any unregistered interest which may have existed before registration. This means that a person who becomes a registered proprietor of Torrens interest can be secure about their transaction. They will not be subject to any unknown pre-existing interest. However, it may operate unfairly to those who have pre-existing interest to the land. Consequently, there are a number of limited exceptions to indefeasibility, including the fraud exception, as spoken in our case. Thank you very much.